154 to be.
154 to be.
It's not right for me.
It is not
We're
right
saying
for me.
we are unintentionally silencing survivors of sexual violence. It is unconstitutional. We're saying, are we saying she's lying? We want to challenge that. It's not about revenge. It's about, we're saying if we name a perpetrator and 4 years later, so remember the perpetrators more than likely will make bail if it's his first offense. He's out on bail for another 4 years. He's not named. Nobody knows what has taken place. We are unintentionally silencing the survivors of sexual violence, and it is unconstitutional because she can't even name herself. So this is important to me, Storm, because 4 years ago I was charged with the protection of harassment. Criminal charges was laid against me by an alleged perpetrator. For someone working in the sector for so many years, it was really scary. You know, we had a legal team on standby in case the police come and arrest me for this matter. So I've been doing this work for 30 years, and then to be charged in a criminal matter. I would say rightfully so. If it's a minor, we want to protect the minor, but if it's an adult, the adult should choose whether he or she wants to be named. We've seen it even in the Epstein matter, how perpetrators' names have been redacted from court records, you know. We see the naming of perpetrators right across. I mean, Giselle then went public, you know, and she said, no, I don't want to be faceless and nameless. The shame is not mine to carry, and that is the thing with sexual violence. The shame is not mine to carry, and we want to say survivors most of the times wants to be named, and this is shifting that shame from them to say no. Again, it's something almost, I want to say globally, are we protecting perpetrators of sexual violence?
The Women's Legal Centre is in court today representing Caroline Peters, and we're challenging the constitutionality of two sections in the Criminal Procedure Act. The first of which criminalises the publication of the identity of an accused person of a sexual offence before he has pleaded. This is a law that only applies to sexual offences and extortion, no other laws. We believe that this law seriously impinges the ability for the police to investigate and the prosecution of sexual offences. So we believe that if an accused person is being able to be named before he has pleaded in a sexual offence, this will assist the cases. The other challenge is against Section 335 and Section 154(2)(b) of the Criminal Procedure Act, which criminalises a complainant in a sexual offences matter of naming herself in a sexual offences case. We also have a campaign running at the moment, which is to encourage the public to engage with an online campaign we call Name Him, where people can symbolically name perpetrators of sexual violence before they have pleaded through an emoji code that is cannot break it, but it's an absurd law, so this is an absurd way of us doing so.